Not surprisingly, as soon as the report was made public last Thursday, there was the predictable squawking from those who do not like the idea of a Bill of Rights. Let me quote from George Brandis. He said, "A statutory charter would bring about the most important de facto alteration to our system of government by transferring the ultimate decision-making power on politically controversial matters to unelected judges." It's one of their great complaints. He went on to say that in future it is the courts, not elected governments, which will have the final say in such issues as military conscription in wartime, the rights of trade unions and gay marriage. Bob Carr, who, despite his enthusiasm for American culture and history, is implacably opposed to a Bill of Rights, said that judges would be able effectively to strike down federal parliamentary legislation. Every word of those two quotes is complete nonsense if you're talking about the charter model that Brennan recommends. Now, let me tell you, there are some standard arguments against a Bill of Rights, and I want to identify them because I want to explain to you why those arguments are simply misconceived or aimed at the wrong target. They are these. First, that our rights are already adequately protected by the common law. Second, that they transfer power from elected parliaments to unelected judges. You've heard traces of that already. Third, that they confer disproportionate power on minorities. Fourth, that they don't work anyway. And fifth, that they'll be a lawyer's feast. And I want to deal with each of those briefly in turn. First, that our rights are already adequately protected by the common law. The best illustration why that's wrong is the case of Al-Kateb. Now, can I invite you, please, to indicate, hands up, who has heard of the Al-Kateb case? That is very impressive. That is really, you know, that is the biggest percentage of any audience I've spoken to who's aware of the Al-Kateb case. It ought to be 100%. I think it was about 40%. But normally, in most audiences, it's around about 2 or 3% who've actually heard of that case. For the others who haven't heard about it, Al-Kateb was an asylum seeker who came here asking for protection from persecution. He was banged up in Woomera. He was refused a protection visa and couldn't bear it in detention, so he asked to be removed from the country rather than attempting to appeal. But he continued to languish in detention because he couldn't be removed, and he couldn't be removed because he's stateless. And the Migration Act said at the time that a non-citizen who didn't have a visa must remain in detention until they get a visa or until they're removed from the country. Now, we know it's not an offence to come here without papers and ask for protection. But there's only two doors out of detention. One is a visa and the other is removal from the country. He'd been refused a visa, he couldn't be removed. So what do? The Howard government argued all the way to the High Court that he, not suspected of any offence, not suspected of being a risk to the community in any sense, he could remain in detention for the rest of his life. And by a majority of 4-3, the High Court said that was what the Act means, and with that meaning it is constitutionally valid. If you think your rights are adequately protected, bear in mind that it's constitutionally valid to legislate for an innocent person to be jailed forever. I don't think that's adequate. Another example, a provision that was introduced into the Migration Act shortly after the Tampa episode said that in substance decisions of the Refugee Review Tribunal couldn't be questioned or overturned by any court on any grounds whatever. There was a woman who'd been in Curtin Detention Centre. She had converted to Christianity. She began preaching in Curtin against Islam. Various people used to come along and listen to her talk. One of the people who came along, let's call him Hussein, used to take notes. One day, on the 1st of August 2003, Hussein left Curtin and left Australia and returned to Iran of his own volition. A couple of weeks later, this woman received message from Iran that she was in deep trouble because Hussein, as it turns out, was a Basiji informer, and he had told the authorities in Iran that she had been preaching against Islam. The penalty for a woman doing that is stoning to death. Now, in her RRT Refugee Review Tribunal application, this woman called 5 witnesses, all of whom said that Hussein used to come along and listen and take notes, and then he'd gone back to Iran of his own accord, and she had heard that he had informed on it. The Refugee Review Tribunal member considered the case and decided as a fact that Hussein did not exist, that his existence had been fabricated in order to improve her claim for a protection visa. He therefore refused her claim, and next stop for her was back to Tehran to be stoned to death. When the matter went to court, the department records for Hussein were subpoenaed and were produced, and they showed that he existed and he had been in Curtin and that he'd left Curtin of his own accord on the 1st of August 2003, exactly as the witnesses had said, and therefore the decision of the RRT member was simply plain wrong. I thought this would be one of those walkover wins in court, which is rare enough in migration issues, but no, the department sent along a barrister to argue that it didn't matter that the Refugee Review Tribunal was wrong as a matter of fact. The decision couldn't be challenged because of the provision that had been introduced shortly after the tamper. And the only legal grounds on which it could be challenged would be to show that it was made in bad faith. Fortunately, the court decided that it was evidence of bad faith in decision-making, that the tribunal member hadn't even troubled to ask the department for the file of Hussein to see whether or not he existed. But for that narrow decision, she would have been knowingly sent back by Australia to Tehran to be stoned to death, knowing that it was factually incorrect in the decision that led to that result. This seems to me to be completely incompatible with the notion that our rights are adequately protected by the common law. The second argument is that a Bill of Rights would transfer power from elected governments to unelected judges. Now, it's really hard to know why people like Carr and Brandis, who ought to know better, continue with this proposition. If they're talking about the American Bill of Rights, it's correct, because in America, the Bill of Rights allows judges of the Supreme Court to strike down legislation if it contradicts any of those rights. But the dialogue model, which has been proposed by the Brennan Committee, does nothing more than this. First, it says that when the Parliament is introducing a new law, it should produce a certificate of compliance, in other words, saying that it complies with the various rights identified by the Charter. If the Parliament does not, if the new legislation does not comply with the Charter, if it unreasonably erodes the rights recognised by the Charter, then the Parliament can say, well, nevertheless, we intend to pass this law. In other words, they can pass a law knowingly that does not comply with the Charter rights. But they have to say so clearly. If they pass a law thinking it complies with the Charter, and if the matter comes before a court, and if the court thinks that the legislation does not comply with the Charter, then the court is entitled to give notice to the Attorney-General that the statute is non-compliant, and the attorney can then make submissions about it. And if ultimately the court finds that the statute does not comply with the Charter rights, then it can say so, but it has no other effect than that. It simply identifies Charter non-compliance. They cannot strike down the law as being invalid. How that amounts to transferring power to unelected judges, frankly, is a mystery to me. The third thing a Charter does, and it's one of the most powerfully important aspects, is that it requires public authorities to conduct their activities in ways which respect the rights recognised by the Charter, so that bureaucrats in conducting their work have to have an eye to human rights as recognised by the Parliament. It seems to me to be only capable of doing good. The third argument, and this has been advanced by Cardinal Pell, surprisingly, is that a Charter would transfer disproportionate power to minorities. And in one sense, he's right, because in Australia, we have a curious attitude to human rights. Most people in Australia think that human rights are important, and yet the historic fact is that many Australians watched with unconcern as David Hicks was held without charge and without trial by our ally for 5 years. Many Australians watched either with unconcern or with active enthusiasm as thousands of innocent children and women and men were held behind razor wire because they had come here asking to be protected from persecution. How is that consistent with the notion that human rights are important?